Hey, I'm Paul Rabley, and in this video, we are going to talk about exactly how a probate works when somebody dies without a will. I'm Paul Rabley. I'm an estate planning attorney. I help our clients get and keep their legal affairs in order. It happens often. People pass away without a will. They say something around 6 out of 10 people, adults in America, have no will. So obviously it happens all the time. People pass away without a will. When somebody dies without a will, the law declares that they died intestate. Intestate means they died without a will. Testate means they died with a will. All right, so we're going to talk about the intestate probate. Louisiana, we call it succession. Other states call it probate. It's just that that procedure when somebody dies with or without a will. If they owned something in their name, they've got to go through the court system with attorney involvement and get judges to oversee the administration of stuff to the appropriate people. Let's jump right into it. So to really tell you how that intestate probate works, I got to lay out just an example, and I'll try to use a fairly normal example. So let's call him Ike. I'll call him intestate Ike. Ike died without a will. He was 75 years old. He wasn't married when he died. Maybe his wife died years earlier, or maybe he was divorced, but Ike had 3 kids. And we have to, to give you an example, I got to go through some assets that Ike owned when he died. Let's say, like anybody else, he owned a home. At the brokerage firm, he had an individual brokerage account, and he had an IRA. Let's call it a traditional IRA. He had some accounts at the bank. He had the typical checking account. He had the savings account. He had a CD. He had some U.S. savings bonds. He owned a car. And then, he had a few little debts and bills, and he was 75, so he was debt-free. He didn't have any mortgage on his home, but he had some, monthly housing expenses, the normal stuff, utilities, water, insurance, liability insurance, homeowners insurance. So he had all that going on, and then he had a few credit card bills. Nothing big, but, $5,000 to this credit card, $10,000 to that credit card. All right, so here's what happened when Ike died. The first thing that happens is they got to have a funeral. And so the 3 kids start kind of wondering what to do because Ike just never got around to planning anything. He was 75, it was on his list, he was a procrastinator, he knew he wanted to get some legal affairs in order, but he just never got around to it. He died suddenly. So the first thing the kids got to get through is they've got to figure out how to cover Ike's funeral expense, and let's say that's $15,000. So what they'll do is they may call the bank and find out that the bank account is frozen, and so they may just pony up the money themselves. They may grab one of Ike's credit cards, and if that goes through, they'll use Ike's credit card for his funeral expense. So they get through that. That's like within 2 or 3 days after Ike died. And then maybe a week after Ike died, maybe sooner, they go to Ike's bank, they go to Ike's brokerage firm, or one of the 3, or 1 or 2 or 3 of the children do it, and they're pretty much quickly told, I'm sorry Ike passed away, but our state and federal law requires that our financial institution freeze Ike's accounts. We can't give you any information. And so those financial institutions will tell the children that they need either what's called letters of administration or a judgment of possession. And again, this is the Louisiana probate procedure. Other states, I'm sure it's similar, but you'll need to check with your state if you're not in Louisiana. So that's about the time that the kids contact the lawyer's office. And maybe now it's 10 days after Ike died. And so I know at that time there's three children, and I know Ike died without a will. And so I'm like, I got to talk to all 3. And if y'all aren't all local, if you're not in town, let's set up a time where we can do a conference call, because I know I'm going to need cooperation from all 3 and a really, good plan up front that everybody can agree on that we can just implement over the coming weeks or months as we try to settle Ike's estate. So in that first discussion, we'll talk about things like, okay, so Ike didn't have a will. Let's go over what our state intestate law says as to who gets Ike's things since he didn't have a will. And in this case, he didn't have a spouse, but he had 3 kids. So Ike's 3 kids are his heirs in equal portions. I'll go over, what did Ike own when he died? That plays a role into the steps we have to take. And then they tell me all the things that he owned, from his home to his brokerage account, to his bank accounts, to his vehicle, to his savings bonds. And they'll tell me a little bit about the bills that are currently due, the household bills, a few credit card debts. They'll tell me that they paid the funeral expense on Ike's credit card. So now I've gathered some information. And so, okay, and then I'll say, okay, well, here we go. Here's what we got to do. Here's the steps to get Ike's estate settled. I said, number one is we've got to get what's called an administrator appointed. And I'll tell the three kids, it's usually one of the kids. And so the administrator's job, before you decide who it should be, is the administrator's job is to really work with our office and gather all of the appropriate asset information, collect all the bills, the debts. Needs to be somebody organized. That administrator needs to communicate with all of the heirs as we progress down this path of getting the estate settled. So between the three of you, y'all really should pick one of you to be the administrator of Ike's succession or his probate. So they decide on maybe one that's local and one who's kind of responsible. And I'll tell all three, we need Ike to be what's called let's call the administrator Al. I'll say we need Al not just to be an administrator, but we need Al to be what's called an independent administrator, meaning he can take a lot of the necessary actions independent of court approval. So I say if Al is going to be an independent administrator, all three of you have to sign an agreement allowing Al to be an independent administrator, which they do because they've been told and they're now under the impression that things will go quicker and things will be easier if Al is an independent administrator. So we prepare a bunch of court paperwork and we get the three heirs to sign it, and then we get it back and we take it down to the courthouse and we file this petition to open Ike's probate and have Al appointed by a judge as the independent administrator. So we file all that paperwork, all those pleadings at the courthouse, and then we sit around and wait for a while. How long do we wait? It varies from courthouse to courthouse, judge to judge, but let's just say for purposes of our example, in a month or a month after we file the paperwork, we get the order back from the judge. The judge's office reviewed all of the paperwork and agreed to sign the order that Al was the independent administrator of Ike's succession. Now what? Now we do the paperwork to get the estate a tax ID number. Now we get these court orders, or what we call letters of independent administration. We get certified copies from the courthouse. We give Administrator Al several certified copies of these letters of independent administration. Kind of crazy term, but that's what it is. And now Al goes to Ike's brokerage firm and establishes an estate account. So that account will be titled something like Estate of Ike with Al as independent administrator. And with the appropriate court orders, or quite frankly, with the appropriate letters of independent administration that the clerk of court issued, the brokerage firm will move the assets that Ike owned from Ike's frozen account into the new estate account. Al may also set up an estate checking account at Ike's bank. And with these letters of independent administration, the bank will move Ike's bank account money from the frozen checking account, savings account, and CD into the estate bank account that Al can oversee. So that was a process of moving assets from frozen accounts into one or more new estate accounts. And in that first meeting, I would have said, kids, what do y'all plan to do with the home? And in most circumstances like that, they say, we want to sell it. We got our own home. We don't need Dad's home. We don't need Ike's home. We want to sell it. So as the independent administrator, Al, maybe he puts a sign in the yard, he gets a realtor, whatever, but he puts the house up for sale. He has the authority to do it as the independent administrator. At some point, probably a few months down the road, because he's got to find a buyer, they've got to sign a purchase agreement. The buyer's got to go get all this financing and his loan. And so there's a closing maybe a few months later. And at the closing, the check is payable to estate of Ike, and independent administrator Al will deposit those proceeds into one of the estate accounts at the bank or the brokerage firm. In the meantime, independent administrator Al is going to use those estate accounts to reimburse whoever paid for the funeral, to pay off Ike's credit card bills, to continue paying the monthly expenses at least until the house is sold. Al will use the estate funds to pay for the utility bills and the homeowner's insurance and maybe even the car insurance until the vehicle is sold. Al may sell the vehicle, and when he does, that check will be payable to estate of Ike. Al will deposit that into an estate account. And in the meantime, the probate court rules require that us attorneys prepare an inventory of all the assets that existed on the date that Ike died, along with a list of all the debts and all the other appropriate pleadings that us lawyers have to prepare to follow the procedural rules that our state requires. And in the meantime, Al will probably take care of Ike's final income tax return. Let's say he died in November of 2019. Well, Ike's final income tax return is going to be due on April 15th of 2020. So Al is going to go see the accountant or the tax preparer or the CPA and make sure that Ike's final income tax return is all done. And then we'll go back to court with another set of pleadings asking that all the heirs will sign off on. So we want to maintain real good communication with those three kids through the whole process so they don't have any problems signing all of the court pleadings that we get them to sign from time to time, and all of the other financial institutions forms that the three kids will have to sign from time to time. Really want to keep real open and transparent communication the whole way through. So now we're getting towards the end, and the kids have signed the final court pleadings that we prepared. We file them at the courthouse, and then we wait. And maybe we wait a month or so, and maybe we don't hear anything from the judge's office, so we call the judge's office. Hey, I know it's sitting there on your desk. Will you sign it, that judgment of possession? Ultimately, they sign it. We get certified copies of it. And then that's that final order that orders really Ike or Al for... orders Al to disperse or transfer any remaining estate assets to the three children equally in accordance with our intestate rules that exist. So that in short, or in long really, is how a probate with no will gets handled. A little bit different procedure from when there is a will, because when somebody does have a will, they name the executor in their will. But when somebody doesn't have a will, then somebody has to step up and ask a judge to be appointed as the administrator, or as I referenced, independent administrator earlier. Now, a couple of scenarios where things can be different. Let's say Ike, let's say all he had when he died was his house, and he had no bills, nothing that really needed to be what we call administered. Then we maybe could have just skipped the step of Al being appointed as an administrator, and then really just petition the court in one set of pleadings. And in those pleadings, we would have laid out the fact that Ike died without a will. He had three kids. Based on our intestate rules, the three kids are the heirs, and we'd ask a judge to sign an order ordering that house be transferred to the three kids. A judge would sign it, and then the order would be recorded in the real estate records, and that would be what would transfer title of that home to the three kids. That might be if the kids want to keep the home for the long term, maybe they want to rent it or whatever. And so sometimes when there's no what's called administration necessary, we skip the step of having an administrator appointed. And all right, so there you have it for what it's worth. It's you may need to watch this a couple of times to really get the gist of it. But I've done this so many times over and over and over again that I just kind of flew through it because I didn't want to take too much time of your time or mine, quite frankly. But to give you an idea, some people who may be watching this video might be, before they watch it, they're like, I have no idea, no earthly idea what a process could be to deal with a probate when somebody dies without a will. So there you have it. Every state's a little bit different. I work and help our Louisiana clients. You may very well be in a different state. Your state may have somewhat different procedural rules. You'll just need to check with somebody in your state to see what the procedure is like to handle an intestate probate in your state. Last thing, make sure you hit the subscribe button so that you don't miss anything. Tune in 10 a.m. Central Time every morning. More estate planning education. I'm out of here. We'll see you tomorrow. Take care.